Let's proceed.
Your Honor, plaintiff has filed a lawsuit that is claiming unpaid billings. The defendant responded. Lawsuit was filed on March 18th. Defendant responded initially without a sworn denial, and we did satisfy the prima facie case. That has not been objected to for the fees, for the accounts that are due. Then the defendant filed an amended answer on October the 8th with a sworn denial. We are objecting to that sworn denial. Happy to launch into the objections at this point, if that's satisfactory at this moment.
Go ahead.
Continue.
Yeah.
The person, I think we start with that, that's making the statement on behalf of United Rentals has made 5 brief statements. We believe that all of them are outside of the sufficiency for what is required under Rule 185. But specifically, I would like to start with number 2, when he says, I am a branch manager for United Rentals. I have personal knowledge of the facts stated in this affidavit due to my capacity as the branch manager. He was not the branch manager when our client was doing business with United Rentals, and that's been some time ago. But the last billing that we sent to United Rentals was in April. He became branch manager in October. So his personal knowledge as to the client and as to the billings and to the activity that went on with Cactus Power and Light does not exist in a personal nature, but may exist in some nature that he has alluded to, but is not satisfying Rule 185. The next position that he takes is that he says, after reasonably diligent search, which I think case law would characterize as conclusionary, both words reasonably and diligent. And he's making a statement that there is no executed contract, and he follows that in number 4, saying that there similarly, so he's actually going back to what he said in number 3. After reasonable diligent search, he didn't find any outstanding invoices. And then in number 5, additionally, no record exists. Well, I've attached exhibits that, number 1, represent that he was not the branch manager at the time of the activity with Cactus. I've attached an exhibit showing that there was substantial amount of activity between Cactus and United Rentals, and over $100,000 in payments were made to Cactus. I've also attached an affidavit that I know cannot be considered factual at this moment, but it does indicate who the party was that was doing business for United Rentals with our client. And in fact, he does say in his affidavit that one of the major billings was the fact that a generator rented by United Rentals was never returned. And he said its location's unknown, but Cactus did not receive that back. And that's $40,000 of the 60 plus that is being sought in this lawsuit. So we believe that most of what he had to say was conclusionary. Some of it was disputed by a prior employee, and he never was on board when all this activity took place. So he can't, his testimony cannot be asserted as to the time frame of the work that was done.
Response?
Your Honor, we're not here to try the case. Plaintiff's motion asserted that there was no fact issue because the defendant didn't have a sworn denial. defendant timely supplemented their answer with a sworn denial. So our stance is that there is now a fact issue sufficient to deny plaintiff's motion. I can kind of get into each of those objections here if you like.
No, I think it is what it is. So I'm going to deny the motion for summary judgment. All right, guys. Let's go ahead and do you have an order for me?
Yeah, it should. I think one was filed by mistake, and then I think it updated one was just filed within the last couple minutes here.
I don't see it. You said you uploaded it recently?
Yeah, it should have been filed right at 3:52.
Okay.
Order denying plaintiff's motion for summary judgment revised.
Yeah, we wouldn't have gotten it yet. Just email it to Rhonda and just make sure it says that it was heard on October 31st. So just do an amended version that was heard on October 31st, 2022. And I'll go ahead and get that signed. You guys have a great rest of your day. Okay.
Thank you.
Thank you, Your Honor.
Thank you, guys.
Thank you, Your Honor.
All right. I think we're here on our last hearing of the day, and that is motion to compel. Is that correct? Are you guys here on the Sales versus Anthony
Yes,
case?
I'm sorry, Your Honor. I am. Yes, Turner Field here for the defendants.
I'm here for the plaintiff, Your Honor. I'm sorry. I thought it was a motion to quash.
Oh, I'm sorry. It's styled as a motion to compel. I apologize. Let's go on the record on DC 213988 Solis versus Anthony Jr. Counsel, make your appearances.
Jim Zaley for the plaintiff.
Turner Field for the defendants.
All right, let's go ahead and proceed.
So, Your Honor, it's our motion to quash the deposition notice of the plaintiff in this case. The defendants in this case were both deposed by Zoom, and defense counsel in this case has requested a live deposition of plaintiff and plaintiff's experts. We're here today on the deposition notice for plaintiff. Lead counsel on this is Rob Lohr with our office, who's actually in the Atlanta office. And so Mr. Lohr has requested that the depositions be done by Zoom so that he can attend remotely as well, without having to incur the expense of flying into Dallas for the deposition. Same thing with our experts, Your Honor. They're located in the Houston area. And we've asked that those be taken by Zoom so we can avoid the expense of bringing everyone together here in Dallas. Opposing counsel, I believe, is insisting that the depositions take place in person. I'm just covering this hearing, so I don't know the exact reason why, but our request is that it be done by Zoom.
Response?
Your Honor, first of all, I've been asking since probably August to take these depositions in person. No reason has ever been given until they filed their motion to quash exactly why they would not agree to have them in person. I attached to our motion, and as part of our conferral email communications between myself and plaintiff's counsel, I offered to put my clients up for deposition in person. I gave them that right. They elected to have the deposition by Zoom. We believe that we have a right to take the depositions in person in order to be able to question them face to face. If a attorney who is based in Georgia is going to take on a case that occurred in Texas and involves Texas citizens and corporations, they shouldn't be able to feign undue hardship when they're called to Texas to take on the case. Furthermore,
well, let me just say this: the law was according to Judge Hoffman. I would allow this to go forward via Zoom. I think it's, I don't have a problem with that. Has anyone looked at the most recent emergency order of the Supreme Court on this issue to see? They keep kind of massaging the standard here, like as the COVID pandemic has evolved. What is the current status of that in terms of the court's discretion making this type of decision.
Well,
Go
The
ahead.
court has discretion, and I would say that the current order expires, I believe, on the 2nd of November. And I would just also state that there's been no explanation given that COVID is even an issue to be concerned about.
And let me just say this, and that's not really my point, is that to me, it's the world according to Judge Hoffman. I would say that I'd let the parties make these decisions themselves, but it's the producing party if they want to do it via Zoom. And I understand why I would allow it to happen if I have discretion. If the Supreme Court says, hey, you guys have to agree on this, you're not agreeing, then I would have ordered to be in person. But it sounds like under the current order, I have discretion.
Yeah, if I may share my screen, Your Honor, I've got it open.
Okay, thank you.
All courts in Texas may, in any case, civil or criminal, without a participant's consent, allow or require anyone involved in a hearing, deposition, or other proceeding, including but not limited to a party, attorney, witness, etc., to participate remotely. So it's within the court's discretion.
Okay. Since it's within my discretion, if the parties wanted to agree to do it in person, I would allow it to be in person. If the parties want to agree, if one side wants to do it remotely, my thought is it's going to be remotely. So that's how we're going to do it. And do you have a proposed order on this, Mr. Zadie?
I believe one was filed.
Let me double check and see if we have it.
I'm not seeing it actually, Your Honor, so I'll have one filed. Oh, no, it was filed. I see it.
Well, when was it filed?
I'm showing. October 13th.
I see the motion, but I don't see an order. Was there an order filed too?
I'm seeing one here in our file that looks like it was filed with the motion, but I can check with Rob and make sure it gets in.
Let me double check that. I don't see it. I'm looking at online right now, or on the. Let me share a screen and so maybe you can tell me which one you think it was filed with. Mr. Zadie, which one was it filed with here?
I saw that it looked like it was filed with the supplemental motion to quash. Plaintiff supplemental motion to quash there on the 13th. But I don't see on your docket the order, Your Honor. So I'll have them refile it or file it.
There wasn't an order attached to that. Maybe it's the object. Yeah, I don't think we got it.
Okay.
Make sure that when you do that it says that it was heard on October 31st, 2022, and then share a copy with Mr. Field. And good luck with everything. Anything else going on? Anything else you guys need my help with?
No, thank you, Your Honor.
Your Honor, I just would say I'd ask that make sure they give us dates before the close of discovery. It's been an issue getting dates from opposing counsel.
You need to give him at least 3 dates by tomorrow afternoon.
Understood.
Okay, Mr. Field?
Thank you.
Thank you. You have a great rest of your day, guys.
All right. Bye-bye.
Okay, Tony,